Hello everyone, this is Rajiv Askhana from immigration.com, the law offices of Rajiv Askhana PC. I have received some requests from both actually the journalistic community as well as our employer community asking about information regarding this complaint filed against Infosys Technologies, a lawsuit filed in the Eastern District of Wisconsin by one Ms. Brenda Koehler against Infosys, stating that Infosys has discriminated based upon national origin. Now, I need a lot more information in order to be accurate, but just looking at the face of the complaint, I can give you my first impressions. And hopefully that answers a lot of the issues that people have in their mind about what this complaint really means and um, how does this process work typically. So I'll make a few comments as I go over the complaint. I read it this morning at the request of a journalist acquaintance who had ultimately they did not write on this issue, but they did want me to take a quick look at it, and I did, and I found a bunch of things very interesting. So I'll make a few comments as we go along. Here you see this is the complaint filed by Brenda Koehler, plaintiff against Infosys Technologies, doing business as Infosys Limited. Okay, and this is they are requesting a trial by jury. Interesting thing is that they filed it as a class action. So what happens in a class action is it has its own pros and cons. When we file a lawsuit as a class action, what we are saying is even though one person or two person or 10 people are named as plaintiffs, as people who are hurt by this, they actually represent a lot many more people who are too numerous to count, and they have all not yet been approached or identified. So then it becomes a class action. There are certain elements in a class action. As we go along, you'll see there are allegations in the complaint that deal with class action, such as numerosity, too many people, commonality, there's a common cause of action, etc., etc. So the problem with class action is that class actions tend to become a lawsuit within a lawsuit, because when you file a class action, first thing that will happen is will the class be certified or not? That kind of becomes a lawsuit within a lawsuit. And class action complaints carry with them a heavy burden of documentary proof, as well as overall, when the litigation proceeds, it's a much heavier burden of documentation, because these people are representing an entire class of unnamed people. Okay, so here there is one plaintiff who claims to represent a whole class of people who have been wronged by Infosys because of their alleged discrimination based upon national origin. The complaint is this, that I am an American, I, Brenda Koehler, am an American, and Infosys did not hire me just because I'm an American. They wanted to hire somebody of Asian origin, South Asian origin, somebody from Bangladesh, India, Pakistan, etc. So as you go along, first there's an introduction. They talk about there is a systemic company-wide discrimination against individuals based upon their national origin. And this is the Title VII complaint based upon a violation, a discrimination that that stems from somebody's national origin. They talk about, 15,000 individuals are employed here and 90% are of South Asian descent. I don't have any way of verifying this information. But the complaint says that there are 15,000 people employed by Infosys in USA, and 90% of them are South Asian. Now, this by itself is not a problem, but when you start discriminating, if there is indeed discrimination, remember, this is just a complaint. Somebody alleging something doesn't make it so. Okay, so this is a complaint. Until it's decided, matters have been brought before a jury, and cases have been put forth and decided. There really is nothing here that we can say is decided. So everything here is an allegation, no more, no less. Okay, it could be true or it could not be true. According to the complaint, Infosys has reached this grossly disproportionate workforce by directly discriminating against individuals who are not of South Asian descent. Okay, so here is where things get a little confusing. I think this complaint has not been reviewed or assisted by an immigration lawyer or somebody who is an expert in business and professional immigration, because some of the allegations in the complaint make no sense. Some others may make sense depending upon ultimately what transpires. Do note that a complaint is merely a roadmap. It is not the detailed picture of what's going to happen. It's merely a complaint is supposed to have enough allegations to notify the defendant, Infosys, that this is what we are alleging and this is what you have to respond to. So it's based upon something called notice pleadings. As long as there is enough notice, Infosys would be put on alert on what is being alleged against them, and they can then answer this. The complaint says that the discrimination resulted from abuse of H-1B or the very high workforce of Asian workers came about because of abusing the H-1B visa process rather than hiring qualified individuals already in the United States. Now, the allegation on its face is wrong. It's legally unsustainable unless it is also accompanied by an allegation that Infosys had an affirmative duty to recruit from the local workforce, which is actually true. Under the H-1B laws, an H-1B dependent employer, any employer 15% of whose workforce is H-1B workers, they are required by law to engage in local recruitment. This is where it gets complicated. The recruitment has to be of several different kinds: direct recruitment, indirect recruitment, active recruitment, passive recruitment. So those allegations are missing, and that's why I said I don't think this complaint has been reviewed or assisted by somebody who practices business immigration, employment-based immigration. But the thing about complaints is, even if they are facially deficient, they can be readily amended. Federal courts don't dismiss complaints just because they are insufficient usually. The second part of the allegation is, and by abusing B1 visa system to bring workers from South Asia. It appears to me that a lot of this complaint, or at least some parts of this complaint, are based upon hearsay. A hearsay is something that is a statement repeated out of court. Let me rephrase that. A statement made out of court which is being produced in court as evidence of the truth of the matters asserted. So somebody said something outside the court. Instead of bringing the person in, we are bringing that statement in to say this is the truth. There are some exceptions to the hearsay rule, but this part, for example, abusing the B1 visa system, this looks more like coming out of newspaper reports or newspaper allegations. Then it talks about Ms. Koehler being a US citizen. Infosys discriminated against Mr. Koehler, choosing to hire somebody from South Asia instead of her. Okay, this is a heavy burden usually. She's got to prove that she was indeed qualified for the job and that the reason she was not hired was purely because of her national origin. That's what she would have to prove in order to prevail on her Title VII claim, as far as I know. Then about the parties, by the way, here is the case number in case you want to pull the complaint. I'll be happy to share the complaint with you. I have it here. I'll try to get it posted. I just wanted to make a few quick comments. But if you need it, if you are a member of the media, just send a request to media, media, at immigration.com. If you are a member of our general public and our community, just send an email to firm, FIRM, as in law firm, at immigration.com. We can send you the complaint, it's no problem. And defendant, okay, then they talk about jurisdiction and venue. These are some technical matters that show to the court that the federal court has jurisdiction over this case. Now, here's an interesting part. It looks like this paragraph 12. What does this tell me? This tells me that, of course, before you bring a Title VII complaint, you have to go to EEOC, Equal Employment Opportunity Commission. So it looks like they did go to Equal Employment Opportunity Commission. They filed a complaint, and EEOC chose not to sue. EEOC can choose to sue the employer, or they can choose not to. EEOC actually picks on very, very few complaints. So they choose to sue in very few matters. So just because they refuse to sue does not mean this is a weak case. And just because they issued a right to sue does not necessarily mean it's a strong case. There are two kinds of notices, again, as far as I know. They issue something called dismissal and notice of rights, which I have noted right here. Dismissal and notice of rights usually means that they've found no cause of action. But when they issue a notice of right to sue, that could very well mean that previously EEOC tried to mediate the matter, or there is actually some factual basis or some sound basis for this complaint. It's difficult to say from here. Then we talk about the factual allegations. This was a case involving a position of VMware. She's a VMware certified professional, and she has done VMware installation and support. So she applied for the position as a lead VMware Windows administrator with Infosys. Now this is where things get a little murky. Notice this is a lead VMware Windows administrator. She further down complains they kept asking me about, in the interview, Infosys kept asking me about Active Directory. Well, wait, if you're a Windows admin, you've got to know Active Directory. It looks to me, again, I could be wrong about this, just looking at the complaint, it looks to me like she may not have the answers that they were looking for in Windows administration side. So I'm not sure whether this complaint really has any sound basis or not, in fact, but looking at the complaint and the fact that she says she was asked questions about Active Directory, I don't see why not, because it's a position for a lead VMware / Windows administrator right here. So if you are going to be a Windows administrator, asking about Active Directory seems to be okay. So in any case, she says she was perfectly, she has extensive experience in VMware and Windows administration. On April 18th, 2012, she got an email about the fact that she would be interviewed, and the interview was scheduled for 10 a.m. on April 24th, 2012. Now she says, "9:50 a.m., 10 minutes before the interview was set to begin, she was sent another email by Infosys that the interview will require her to call into someplace instead of it being a normal phone call." So I think what they're saying is that this appears to suggest that Infosys was trying to not interview her if possible by changing the modality at the last moment. I'm not sure this makes a case. Remember, the burden of proof is on the plaintiff. They have to demonstrate that it is more likely than not that there was indeed discrimination, there were wrongful motivations. So far from these allegations, I'm not clear that there are. Okay. So now she says, the conference call number she called in, and she says, while the job posting indicated that VMware would be the primary role for the position, Infosys' representative spent considerable amount of time asking her about other subjects, including DNS, which should be quite basic, and Active Directory. Again, if you are a Windows admin, why would you not expect to be questioned about Active Directory? I don't know. Again, I'm making these assertions based only upon the face of the complaint. I don't have any other facts. The lawyers must know a lot more than I do. But right now, looking at the the face of the complaint, again, if it had been reviewed by somebody who understood technology, they would also probably say the same thing, that why would I not ask you about Active Directory if you are going to be a Windows admin? Once again, one corporate principle that emerges from this is please treat people with respect. Anybody who interviews with you, treat them with respect. Don't make them feel like they are being put down or anything. Even if you don't intend any kind of derogatory conduct, sometimes it can come across as that, and that could very well be construed to be discrimination. Again, I don't know the facts. Maybe there is discrimination, maybe there isn't. Looking at the face of the complaint so far, I find no grounds for it. If these are all the allegations they have and all the proof they have, I don't see anything here. Then she says she talked about, and this is the part that bothers me a little bit. If this is true, this would indeed be bothersome. She says she explained her experience with Active Directory, and one of Infosys' representatives sighed and stated, in parentheses, incorrectly, that Ms. Koehler had no Active Directory experience. It's the sigh. It seems almost like it's so burdensome to interview you. And if indeed it happened that way, there's a lesson to be learned. When we interview people as an employer, we should be meticulously polite and meticulously, on our best behavior. There is no reason for us to put anybody down. Okay, so they said Infosys did not hire her. They hired somebody from Bangladesh. Okay, that by itself is not a discriminatory reason. But then they talk about practice and the pattern and practice, and the only allegations they have are right here. They have engaged in a systemic pattern and practice of discriminating against individuals. There is nothing more than that. Now, if this complaint were to be challenged through like a summary judgment, motion for summary judgment, I think they could be in trouble. This case might, if they don't have any more than this case might get thrown out, dismissed with just a summary judgment a motion. They talk about the grossly disproportional workforce. By itself, that's not sufficient. Now, here is an interesting part. There was somebody, Jay Palmer. Jay Palmer was somebody who had complained against Infosys. They had a whistleblower complaint, and Jay Palmer then filed a complaint, and that was actually in the newspapers quite a bit. Infosys retained the services of an attorney called Mitch Allen to conduct an investigation. Mr. Allen testified. That's what the complaint says. Mr. Allen testified. Where? Where did they testify? Complaint is silent. Mr. Allen testified that there are fewer Americans than Indians employed by Infosys. I don't know where this testimony occurred. Then they talk about a former Infosys employee who worked in human resources, Linda Manning, testified that approximately 90% of Infosys employees are foreign workers, etc., etc. But where is this testimony from? And in any case, this would be hearsay. It would not be admissible as evidence unless it met one of the requirements. And I can't think of, trying to think of how they could. Well, if the witness were unavailable for some reason, and the testimony was actually in another legal proceeding under oath, and I think what is also required is that that Infosys was allowed to cross-examine and had vigorously defended that, only then this kind of testimony or allegations would be allowed as evidence. So again, it looks to me as though the complaint has been based upon some very unreliable quote-unquote evidence. I don't know if this is evidence. So they talk about the demographics, and they talk about, and none of that by itself is evidence of discrimination. Infosys' reliance on foreign workers. Now, misuse of H-1B visas. I'm not sure what they mean there are some legally incorrect allegations, but they can be recorrected. They can be corrected and restated. For example, the allegation in paragraph 42, the H-1B visa program is intended to be used to bring foreign workers to the United States when there are insufficient local workers. That's not true. That's not true. However, H-1B dependent employers are required to recruit before they hire H-1B workers. That part is true. So again, this part can be corrected, but I'm not at all sure that this complaint will stand for long. And here, look at this allegation in paragraph 45. This is a very summary allegation. Infosys has a long history of abusing the H-1B visa system by hiring disproportionate number of foreign workers. Wait a minute. H-1B, if you are using H-1B system, you're not hiring locally. You're of course hiring foreign workers. So some of this doesn't make sense. Some of this should be restated. I'm sure that the lawyers involved in this case will get themselves some help in the immigration area, because there are some allegations that could be made that would be quite serious if they were true. So somebody should sit down and look at the facts. If indeed there are basis for this kind of complaint, then it should be restated, and some of the causes of action should be expanded. Now, this part is quite interesting. Infosys's misuse of B1 visas. Well, first of all, they talk about, they say, look at the allegation, 51. Upon information and belief, that means we don't know for sure, but we believe this to be true. Infosys has also engaged in the plainly illegal practice of obtaining B1 visas for its foreign workers. That's not illegal. There is a legal procedure called B1 in lieu of H1. Just Google it. B1 in lieu of H1. When you Google that phrase, you see immediately the first entry I think that comes up is US Consulate in New Delhi. It tells you you can do B1 in lieu of H1 if you meet certain requirements. And then I also made a note, and that's kind of hidden here a little bit. Let me see if I can move this over. This is not a private cause of action. Remember, you cannot file a complaint based upon all the violations of law that you see, unless you have standing. Standing means you should be somebody who is intended to be given the right to file a lawsuit on those bases, which is called a private cause of action. I don't see how this can be a private cause of action. But again, I'm sure these are smart people, smart lawyers. They must know what they are doing. From the complaint, I see these problems. Now this part, improper long-term work, if true, could be the basis of an allegation, but again, it does not give you the private cause of action. It does not give you the right to sue on those bases. There are some legal infirmities. Again, some allegations have been made that are not true legally. Then they talk about according to congressional testimony. That is not evidence. So I'm not sure where that figures into this. Would the court allow something like this? Then government and congressional investigations. Again, Mr. Palmer, a company whistleblower. Unless Mr. Palmer himself is there, what he says maybe doesn't mean anything. And then they talk about Infosys has put into place an affirmative action program which is insufficient, etc., etc. Then they talk about particular instances of discrimination. Again, this is based upon J. Palmer. All of this is based upon Palmer. So Palmer is not a party to this lawsuit. I don't know where does this factor in. I don't know. It depends upon the judge. I haven't researched the rulings of this particular judge. The case has been assigned already. The complaint was filed on August 1st, and the case has been assigned to a judge. I'm not sure how the judge would view something like this. A lot of these allegations are based upon bringing to the mind of the court some ideas that this is a large company and they are beating upon this a small employee who's a single solitary person who applied and was declined. So I don't know where this will go eventually, but the face of the complaint does not show to me anything particularly serious or particularly um, clear cut that says, okay, this case is really in favor of Miss Kohler, and she will have no problem. I think they're going to have a problem with class certification. I think that just the way the complaint is, I think they're going to have a problem with going past summary judgment. This case may never go to jury. So these are my preliminary comments. I do not know if they have a strong enough complaint, but this is a developing document. As the evidence develops, if the judge does allow it to go forward, maybe they will amend the complaint a few times. It's not abnormal for a complaint to be amended 2, 3, or even 4 or 5 times. So looking at it the way it stands, if I were the judge and this was all the evidence they had, I would probably dismiss it on summary judgment. But if there is more, and they indeed can produce more evidence, and they have more that they haven't stated, this complaint could go forward and could go into a jury trial. Once again, guys, if you are a member of the media, you can send an email to media@immigration.com. If a member of our community, anybody from the public, and you need a copy of this complaint or comments, send it to firm@immigration.com. Thank you.